And we are live. I hope you guys can hear me. If you can't hear me, just let me know. But I think you guys probably can hear me. I hope so, at least. DLD After Dark will be joining us in a minute once he gets on, and then we're going to go over this case. But I'm going to give you the TLDR before we even get started, in case you need to get out of here. I'm going to lay down what is happening today. A federal judge in a case, it's either known, well, it's several cases that are combined, but where I'm going to refer to it as, right now, I'm going to refer to it as Kipke, but it's actually several different cases. Like, for example, there is also Noravanti, I guess it is, versus Moore, but Kipke versus Moore. And this dealt with a law in Maryland that Maryland passed in 2023, which was a ban on carrying firearms in certain areas. And the judge has issued a ruling striking down a lot of what the state has tried to do. For example, some of the places that it struck down is the carry of anywhere that sells alcohol. So that just does not mean bars, but that also means grocery stores, because like a Safeway, they sell alcohol. It means 7-Elevens, gas stations, anywhere that sells alcohol. According to the law, you could not carry a firearm there, concealed or open carry. It doesn't matter. You could not carry a firearm, even if you had a Maryland license to carry. You are not allowed to carry a firearm in any place that sells alcohol. The judge said that is unconstitutional. There's a few people from Maryland checking in here. Congratulations, guys. Also, there's a carry ban in private property without the consent of the owner. This is very similar to the ban under the New York's concealed carry law, which banned people from carrying in private property unless the person that owns the private property posts signs that says you're allowed to carry. This decision also ruled that unconstitutional. And there is also a ban. There also was a ban on carrying within 1,000 feet of a public demonstration. And it didn't matter if you were actually attending the public demonstration or you were just passing by the public demonstration. Drive down the road, and a couple blocks over, which is in 1,000 feet, there could be a demonstration going on. And since you are within 1,000 feet of the demonstration, even though you have nothing to do with that demonstration and you're just driving to somewhere, let's say you're driving to the range or whatever, you could be pulled over and charged for violating the Maryland law. The judge said that's a bridge too far and ruled that unconstitutional as well. So that's the TLDR. And now we're going to get into the meat of the case. One of the people that we're suing is Maryland Shall Issue, which is a great organization, Firearms Policy Coalition as well. and a bunch of other people, including the Maryland State Rifle and Pistol Association. So let's go ahead and take a look at it once Dark gets back. What's up, buddy?
What's up, man? How's it going?
Are you
This
ready
is
to jump into this?
yeah, this is good news. Sorry, my dog is acting a fool.
Yeah, there's been a lot of good news lately, but let's just jump into it. You know what to do.
This matter. Well, first, what's up, guys? It's
Well, I
dark.
just explain all this. It basically just explains the. So let's just go to talk about the Gun Safety Act of 2023 and stuff like that.
Yeah. Uh, the court provided a complete description of the facts and law at issue in the case in its September 29, 2023 memorandum opinion, which it incorporates here by reference. The court will not repeat that description in its entirety and will instead provide a brief summary. This action concerns plaintiffs' challenges in the constitutionality of the Gun Safety Act, which is totally gay, formerly known as Senate Bill 1, as well as several other Maryland firearms regulations. See Maryland Code, blah, blah, blah. The act took effect in part on October 1st, 2023, which I jumped in and got my Maryland permit right before then. It was like September. Anyway, and it identifies three categories of statutorily defined locations where individuals are prohibited from carrying in, quote, area for children and vulnerable individuals. A, quote,
That's
government.
basically parks, basically.
Yeah. Well, and some other folks, much smarter than I, than my simple smooth brain, had said that that could have been like the parking lot of a retirement home, or like there's so many other things that they could have thrown in
Yeah,
there.
they sold it as parks, but you're right. It could be expanded
Yeah,
too.
they're trying to do catch-alls.
Yeah,
A, quote, government or public infrastructure area, and three, a, quote, special purpose area.
that
There's
would be
actually.
like areas designated for demonstrations and stuff like that. We're gonna get into that later.
Mhm. These three categories include bans on carrying firearms in the following locations: schools and school grounds, healthcare facilities, government buildings, stadiums, museums, amusement parks, racetracks, casinos, and locations selling alcohol for on site consumption, bars, and restaurants. Certain exceptions apply, such as if you're a police officer, just kidding, such as for active or retired. Oh, wow. Wow. Such as for active or retired law enforcement officers.
You gotta love the stagger. The
Yeah, like oh, man, I was totally joking too, by the way. But I should have known. Um, Private property owners with authorized security,
that's like paid armed security.
yeah, protective details, stuff like that. And individuals who transport a firearm inside a motor vehicle. Okay, hold on. Well, I guess we'll dig more into it later. As long as they either have a public carry permit or lock the firearm in a
Container.
container. The act also prohibits individuals from entering buildings on private property while carrying a firearm without first obtaining permission to do so. The private building consent rule. The manner in which permission may be expressed or obtained depends on whether the building at issue is a dwelling or not, I guess. The act provides that an individual carrying a firearm cannot enter a dwelling without the owner's permission. With regard to all other private property, an individual carrying a firearm may not enter or trespass on such property unless the owner or the owner's agent has posted a clear and conspicuous sorry, I just want to be clear, not inconspicuous, clear and conspicuous sign indicating that it is permissible to carry a firearm on the property, or two, has given the person express permission, which I guess would typically be in writing, to carry a firearm on the property. Separate from the act, Maryland also has firearm restrictions in the following locations: in state parks, state forests, Chesapeake Forest lands, blah, 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 blah. Case law on public transit owned or controlled by the Maryland Mass Transit Administration or operated by a private company under contract to the administration. and they cite Maryland Transportation Code. At welcome centers, oh, I guess kind of like rest stops.
Rest stops. That's
Yeah.
exactly what it is.
Welcome centers, rest areas, scenic overlook. Dude, there's specifically, oh, there's the scenic overlook right between Maryland and DC, right? Like it's literally
Yeah.
called a scenic overlook. Bastards. Roadside picnic areas, that's cute, and other public use areas with an interstate and state highway rights of way on the grounds of public school property, on property of state public buildings, improvements, grounds, and multi-service centers under the jurisdiction of the Department of General Services in the Camden Yards Sports Complex.
That's where the Orioles play. It's
Yeah,
actually a really nice area.
yeah. In a casino, that's all that says. At a demonstration in a public place or in a vehicle that is within 1,000 feet of a demonstration in a public place, after being informed, okay, hold on. After being informed by a law enforcement officer that a demonstration is occurring and being ordered to leave the area until the individual disposes of the firearm. So it's almost kind of like being trespassed, right?
Yeah.
You can't just get in trouble.
No,
There's
no, 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 no. You have to be warned, but it's still stupid.
they would still overreach there, I'm sure. On May 16th, 2023, two lawsuits were filed challenging the act and the other related firearm regulations set forth above. Kipke plaintiffs filed the first lawsuit, and Novotny plaintiffs brought the second.
That was the second case was the one brought by Firearms Policy Coalition
Gotcha.
in Maryland.
Kipke plaintiffs make Kipke plaintiffs make the following claims under 42 USC 1983 to challenge the constitutionality of the act and other Maryland firearm regulations. Second and 14th Amendment violations due to restrictions on carrying firearms is applied to state parks, state
Okay.
highway.
The Second Amendment, everyone knows. 14th Amendment takes it takes all the amendments and apply the restrictions to state governments as well.
Yep. State parks, state highway rest areas, mass transit facilities, public school property, the grounds of preschools or pre-Ks, pre-kindergarten facilities, museums, the Camden Yards Sports Complex, stadiums, healthcare facilities, government buildings, locations selling alcohol, amusement parks, racetracks, and casinos, private buildings, and demonstrations. So basically everything that was just mentioned.
Yeah,
And
plus,
demonstrations.
it's selling alcohol for not like for consumption. It's just selling alcohol.
Mm. Oh yeah, that's true. It just specifically it doesn't specifically say for consumption.
Yeah.
Amusement parks, racetracks, and casinos, private buildings, demonstrations in public places. A First and 14th Amendment violation due to the private building consent rule. A Second and 14th Amendment due process clause violation due to Maryland's permit process and an applicant's need to satisfy, quote, subjective criteria. And for a 14th Amendment equal protection clause.
Because basically it's discriminating because retired law enforcement and active duty law enforcement, even if they're in their private lives, are allowed to carry. So it basically sets up a two-tiered system.
Yeah, imagine that. Where we start? Novotny plaintiffs make a similar but more narrow challenge of Maryland's firearm restrictions. Their complaint contains several of the same claims as count one of the Kipke complaint. They allege that Maryland cannot restrict firearms in the following locations: healthcare facilities, locations selling alcohol, museums, and private property without the owner's consent, mass transit facilities, and state parks, state forests, and state Chesapeake forest lands. Because of the complete overlap between Novotny plaintiff's claims and count one of the Kipke complaint, the court consolidated the two cases on July 13th, 2023.
Basically what they're saying is the case is so similar that, but like both plaintiffs are going to get their chance to argue, but since the state's defense is going to be the same, it's going to save the court's time by combining the cases into one case. You see this?
Is that typical?
Yeah. The other case that we did the other day was a combined case. also all the Illinois assault weapons ban cases. Those were all combined, and there was like 6 of those into the Naperville case. So there's a bunch of different cases. So cases usually do get combined, and this one was combined.
Gotcha. Prior to consolidation, Novotny plaintiffs filed a motion for preliminary injunction seeking to enjoin enforcement of the firearm restrictions listed in their complaint. They also filed a motion for summary judgment seeking a permanent injunction on July 20th, 2023. State defendants filed a cross motion for summary judgment and opposition to Novotny. Plaintiff's motion for summary judgment on August 3rd, 2023.
Basically, they're saying, "Oh, you know what? We don't agree that you should be getting a summary judgment. We should be getting a summary judgment." That's what basically what a cross motion summary judgment is.
Yeah. Let's see. Plaintiff's motion for summary judgment on August 3rd. On August 11th, Novotny plaintiffs filed a reply in support for their motion for summary judgment and in opposition to state defendants' motion for summary judgment. Are you wearing a bobblehead shirt?
Yes,
What are those things called?
Funko Pops.
Funko Pops. That is adorable. In the Kipke case, if you guys don't know, Crump has in his theater, he has like an entire, like you could open up a commercial store of
I have
Funko.
over 1,000 Funko Pops.
Yeah, there's like a huge layer of them, and then you see that there's like ones behind all of them, like rows and rows of it. It's hilarious. Everyone's got their thing. My thing is Glocks. In the Kipke case, state defendants filed an answer on June 30th. Kipke plaintiffs filed a motion for a preliminary injunction and a motion for summary judgment on July 3rd, 2023. On July 28th, 2023, state defendants filed a cross motion for summary judgment and opposition to Kipke plaintiffs' motion for preliminary injunction. On August 11th, 2023, Kipke plaintiffs filed a reply in support of their motion for summary judgment, response in opposition to state defendants' cross motion for summary judgment, and reply in support of their motion for preliminary injunction. Now they received a preliminary injunction, right?
Yeah.
State defendants filed a reply in support of the cross motion for summary judgment on September 8th. Then on September 29th, the court issued its memorandum opinion and order granting the motions for preliminary injunction in part and denying them in part.
Like the school ban and stuff like that, they upheld.
Okay. Specifically, the court granted the motions for preliminary injunctions as to Maryland's laws restricting the carrying of firearms in 1, locations selling alcohol for on-site consumption, 2, private property without the owner's consent, and 3, within 1,000 feet of a public demonstration. That is so whack. I cannot believe that was even a thing. The motions for preliminary... You know what? Let me just say this. What comes to your mind when you think of carrying a firearm within 1,000 feet of a demonstration? What situation that happened in recent history comes to your mind?
There's been tons of demonstrations in the last few.
Yeah, but think of one where a few kid diddlers PDF files.
You're talking about the Rittenhouse thing, yeah.
Yeah, I think that was definitely Rittenhouse based. Let's see. Preliminary injunction were otherwise denied. Or I'm sorry, the motions for preliminary injunction were otherwise denied, and the court also denied the motion to dismiss and the motions for summary judgment without prejudice. On October 12th, 2023, state defendants filed an answer to the Novotny plaintiff's complaint. The parties then informed the court that they did not plan to conduct discovery, and they requested that the court renew the motions for summary. Summary judgment for consideration without further briefing. The court renewed those motions on November 17th, 2023. Since then, the parties have filed several notices of supplemental authority and related responses, which the court considers in its analysis below.
Yeah, that they basically one of the notice of supplemental authorities. That means if a case happens while your case is going on, you file what's called a notice of supplemental authority saying, "Hey, judge, look at this case. It said this in that case." one of the notice of like supplemental authority that was filed was the Rahimi case.
Gotcha. In reviewing a motion for summary judgment, the court views the fact in a light the hold on. The court views the facts in a light most favorable to the non-movement. What's that?
Uh, the movement is okay. So it's a legal term, right? So you have
Mhm.
movement and non-movement, right?
Mhm.
If you want to look up what non-movement is, it's basically the parties in the case that did not file a motion. The movement is whoever files the motion. So I think file
Oh,
the
okay. Move, motion,
yeah, yeah.
moving, non-moving. Okay, that kind of makes a little sense.
So
Drawing
basically, whoever did not file the motion would be the non-movement. So, for example, let's say the state filed a supplement of authority citing Rahimi,
then
and
the opposing side would be the non-movement.
yeah,
Gotcha. Okay. Thank you.
yeah. I
Yeah,
like to explain stuff like that so people know.
yeah, otherwise a lot of this stuff is like Greek.
Yeah,
When
well, that's why I like going through the actual. That's why I like reading through it with everyone. So
you don't wanna wait till like December to review this?
no,
Oh, okay. So so sorry. Summary judgment is proper when the movement demonstrates through particular parts of materials in the record, including depositions, documents, electronically stored information, affidavits or declarations, stipulations, admissions, interrogatory answers, or other materials that there is no genuine dispute as to any material fact, and the movant is entitled to judgment as a matter of law. Significantly, a party must be able to present the materials it cites in a quote form that would be admissible in evidence. And supporting affidavits and declarations must be made on personal knowledge and set out facts that would be admissible in evidence. Once a motion for summary judgment is properly made and supported, the burden shifts to the non movant to identify evidence showing there is genuine dispute of material fact. The non movant cannot create a genuine dispute of material fact through their speculation of the building of one inference upon another. And then it cites case law. A quote material fact is one that might affect the outcome of a party's case. It cites case law again. Whether a fact is considered to be material is determined by the substantive law, and only disputes. I don't know why did they do that?
uh,
Like,
with the L.
yeah, was it? Did they correct it or
No, no, no. It was taken from there's if you look it up, there is a complete sentence there, and they're not using the complete sentence, they're using part of it.
okay? Yeah, I noticed things like that throughout.
Yeah, and it's
Documents like
it's
this.
another legalese when they don't use when they're not using like a complete sentence or whatever, they're just using part of a first sentence, whatever, they will do the bracket.
Gotcha. Only disputes over facts that might affect the outcome of the suit under the governing law will properly prelude the entry of summary judgment. It cites case law again. A genuine dispute concerning a material fact arises when the evidence is sufficient to allow a reasonable jury to return a verdict in the non moving party's favor. Cites case law again. If the non movement has failed to make a sufficient showing on an essential element of his or her case where he has the burden of proof, there can be no genuine dispute as
Okay,
to
that
any material
now
fact.
that is where they inserted a word,
Okay, gotcha. Since
uh,
a
used in different ways.
yeah, since a complete failure of proof concerning an essential element of the non-moving party's case necessarily renders all other facts immaterial. Sorry.
Oh, sorry.
Oh,
Yeah,
that's okay.
okay.
No, it's just
Yeah.
case law.
All right. Now let the claims.
Kipke plaintiffs move for summary judgment on counts 1 and 2 of their complaint. They ask that the court they ask the court to permanently enjoin enforcement of the act and other state regulations that ban the carrying of firearms in bars and restaurants, public parks, public transportation, and mass transit facilities, stadiums, racetracks, amusement parks and casinos, museums, near public demonstrations, healthcare facilities, school grounds, government buildings, and private property without the owner's consent. They make this argument under the Second Amendment, and they also argue that the private building consent rule must be enjoined for violating the First Amendment.
Basically, what you cannot tell people that they have to put up signs for something.
Yeah, yeah.
But
I mean, look, I'm even torn for things like that because I absolutely respect individuals' natural rights, but I also enjoy property rights. You know what I mean? So it's you know,
yeah, I mean, they can ask you not to carry. I mean, I'm gonna ignore them, but I don't
sure.
think those signs should have force of law.
Oh, absolutely not. Absolutely not. Similarly, Novotny plaintiffs move for summary judgment on all 3 counts in their complaint. They ask for a declaratory judgment and permanent injunction on the carry bans in healthcare facilities, museums, bars and restaurants, mass transit facilities, state parks, and in private buildings without the owner's consent. Cites case law. And then in their cross motions, state defendants respond that they are entitled to summary judgment on those same claims. Consolidated. Da, da,
Yeah,
da.
basically, that's consolidated movement. Yeah, that's all legalese.
The court previously considered these same issues on the motions for preliminary injunction. Although those motions required a different standard of review than the summary judgment standard set forth above, there has been no discovery in this case, and the facts are unchanged and undisputed. Explaining that no party wished to conduct discovery. Da, da, da. The constitutionality of these provisions is a pure question of law. No discovery is necessary. Further, the court conducted a thorough review of the entire record in making its September 29th, 2023 decision. Accordingly, for the same reasons stated in the memorandum opinion, where the court determined whether plaintiffs were likely to succeed on the merits of their claims, the court now finds that there is no genuine dispute of material fact as to whether the regulations identified above violate the Second Amendment. The court will grant in part and deny in part. Hey, bud. Good to see you, Jordan. The motions for summary judgment in accordance with its prior memorandum opinion and order. And the court will permanently enjoin Maryland's law restricting the carrying of firearms in locations selling alcohol for on site consumption, private buildings without the owner's consent, and within 1,000 feet of a public demonstration. The court will enter judgment for plaintiffs as to those claims. Plaintiffs' motions for summary judgment will otherwise be denied, and judgment will be entered for state defendants.
But basically, what he's saying is that there is, and now he's just going to go into the case law down here, so that's not really anything, Uh,
Yeah.
what he is basically saying is, hey, look, I gave the motion, the temporary injunction on this. The state did not present anything to show why I was wrong, and there is no dispute that everything is the same as it was when I issued that preliminary injunction. And because of that, I can go ahead and make that preliminary injunction permanent through a permanent injunction and a motion for summary judgment. So right now, Judge Russell, George Russell, is done with the case. So the district level court is done. This is at the district level. Now, a lot of people are going to ask me what is going to happen now. And Maryland is going to appeal to the circuit court,
Mm,
which, if you know anything about the circuit court in that area, is not exactly too gun friendly.
not at all.
Nope.
Yeah. And I do
And
want to take a moment and just
I just want to say that's the Fourth Circuit Court. If anybody's wondering, Virginia is is under it as well, and they're not gun friendly at all. They're probably less gun friendly than the Ninth Circuit. So that should tell you
You,
something.
you think so?
Yeah.
Yeah, I mean, yeah, history has shown us that, I guess. Um, it's crazy to see the positive things that have occurred, especially in this area, like post Bruin. I was finally able to get my as a Virginian, get my carry permit in Maryland, which is huge, and I managed to squeeze it in, before all this craziness and before they changed some other administrative things to make it more difficult and more restrictive. But there has been a lot of wins and a lot of positive growth with our rights with all these organizations that have been fighting, and I mean we should show some gratitude and appreciation for those that are fighting. And I I just want to take a second and say, number one, the GOA is incredible. The GOA has helped me in a big way, and Rob Olson is incredible. And
Yeah.
thank you, Crumpy. And also Gilbert Ambler out of Virginia is literally helping me right now. I was served with a federal grand jury subpoena
Oh,
because
Gilbert helping you?
yeah, yeah,
Gilbert.
literally.
Yeah, Jordan. Jordan knows him. We went out to dinner with all those guys in Vegas.
I was actually going to say Jordan also reached out to Rob Olson on my behalf because so a lot of you guys may already know, some of you may not know. I run a company called DLD Hardware, and I sell hardware, jigs, tools for people building firearms, polymer 80s, and all that stuff. And I sold a jig to someone who did some not good stuff, and the ATF they didn't really come after me, right? But I mean, they still served me with a federal grand jury subpoena. And man, those guys, if there is a way to equip yourself with armor between you and the gay TF, those dudes are the ones that did it. I just want to say thank you so much.
Yeah, Rob
Thank
Olson
you.
works for GOA, and
Yeah.
Gilbert does too. So Gilbert is a cool guy, young kid too, man.
Dude, he was so cool, so chill. And he's like, yeah, I'll call him for you. No problem. And oh, I got to do that document. Shucks. But yeah, dude, I am eternally grateful for all those guys, for you, for Jordan Vinro. Jordan is such a great dude as well. And, you know, yeah, it's awesome. So thank you. And thank you to all you guys out there supporting DLD hardware as well. And, supporting John and the homies. I appreciate
Yeah, I
you
think
guys.
Gilbert Ambler has a shirt that says Gilbert Ambler kept me out of jail or something like that.
Really?
Yeah, I'm pretty sure.
I would definitely need to get one of those. I mean, yeah,
Yeah. So yeah, it's cool.
yeah.
It's cool.
But that's why all of the fighting and the small incremental wins and victories we need to celebrate them because we are moving in a positive direction. Even though it may seem like the world is falling to pieces and everything sucks, um, we are having positive movement and wins, and we need to
Yeah.
acknowledge that.
Did that mean private property? Well, the law is dead now, so it doesn't mean this anymore. But yes, it did include if you were staying in a hotel, the hotel would have to post signs allowing gun owners to have their guns.
Yeah.
Yeah.
Yep.
Um, yeah, it's like little victories that we have to take to get our rights back. Like I said, like I've always said, you gotta it's not a single vector of attack. You attack everything on the macro level and the micro level. So you
Mhm.
do attack things like the NFA and stuff like that and all gun laws like that, but you also cannot just put all your eggs in the basket of just knocking down the macro level of
Yeah.
the NFA totally. So even though that you go after the NFA wholesale, you also have to file suits like to deregulate suppressors and SBRs and SBSs and stuff like that. So I see a lot of people out there say, "Well, why don't we, uh, why don't we go after
Like the NFA.
the NFA and stuff like that?"
Like, we are. It's, one incremental step at a time.
Yeah, but or why don't we just go after machine guns? What's in the Vista print box? I'm not even sure. Oh, it's my business cards. So we do have to go after it, but you gotta do it. You gotta do it smart. You gotta attack on multiple levels.
Uh, I just wanna say shout out to Lucas, Warchola, who says he intends to have his carry gun in him. Um Oh, it was a misspell. Okay, I thought you were talking about prison wallet everyday carry. Um, Forgive me. Some people choose to keep their gun in them. There are lots of stories on that.
I'm not showing my business cards because they have a lot of my personal information on it.
Yeah,
So
good
no,
move.
no.
I was thinking of, playing the, voicemail from the special agent at the ATF, but that also contains some private information as well, you know? Dude,
Yeah,
I can't look, I said in 2024, I was like, "Man, I'm gonna make the evidence table debut in 2024 because DLD hardware has been in business, for 2 years now, and I was like, I want to make the evidence table, and I want to see because they always put jigs on the table with, this man was caught with an arsenal of 4 guns and 200 rounds of ammo, right? And then they always put jigs on there, and I was like, well, I want a DLD hardware jig to be up there. So anyway, I guess I could say that I did make the evidence table for 2024, just not in the way that I had intended.
no, my business cards are not NFC. I know that's a big thing now, but mine's not.
What is that the thing you like scan and download all your info or something?
It's like tap it or whatever.
Yeah.
Like they're making business cards now that you can go up to someone's phone and tap it, and it just goes all automatically into the phone.
Yeah, that's creepy for me. That's it, just as creepy as like ground penetrating radar that is in a van that can see through homes as long as you don't have lead-based paint.
Yeah,
Not that that's a real thing that's used by federal agents all the time or
yeah,
anything.
yeah. So with that, I think we are done here, um,
Yep.
and we're gonna get out of here. But just to let you know, this is a victory. Congratulations to the Firearms Policy Coalition. Congratulations to the Maryland Pistol Rifle Association. Congratulations to Maryland Shall Issue. This is a victory, and now it's off to the fourth, where it will be going to a three-judge panel because Maryland's going to appeal. Then whatever that three-judge panel whatever happens with that three-judge panel, what probably will happen is whoever loses will ask for an en banc, which is the complete bench hearing the case. And if it's granted en banc, whatever that three-judge panel decides will be vacated, the the district judge's decision will stand. So it would be just like the three-judge panel never happened. Then after the en banc, the losing side will appeal to SCOTUS, and that can't come fast enough for me.
Yep.
Just
Shout
to,
out to Kurt 24 as well, dropping the links in there. Appreciate you, man. Kurt is one of the best mods in the world.
yeah, it's a victory for a short time until they appeal it. Yeah, what Maryland, what this is, I don't have any inside information on this, so this is just me speculating. I think Maryland is probably going to ask for an administrative stay on the decision. I don't know if they'll get it or not, but pretty sure that they're going to ask for the decision to be stayed.
Yeah. Come here. Frag out was asking where my hamster is. Here's my hamster.
That's
Say
little
hi.
Remy.
Yeah. Say, hey, dude. It's so funny. He says, where hamster?
Yeah,
Why you biting me?
and just
Oh,
to let you guys know, tomorrow I will be at the Guns Out Range Day in
I'll be there
Ashburn. They
too.
got a VIP shoot. Yeah, they got a VIP shoot today, but I did not go.
Yeah, I'll be
I
there
have
as well. What time are you heading up there?
tomorrow.
Yeah.
I'll be up there early. I'll be at the GOA
Okay.
table.
So I'm probably gonna just be there in the afternoon. I'm gonna be there with my sidekick, and yeah, Kurt, don't worry about it, brother. You're good. I saw your message. You're totally good to go.
I'm gonna have
Um,
2 of my sidekicks there.
oh yeah,
Matthew and Nikki are both coming.
don't bite me. Nice. Yeah, anyone that wants to come join us, if you don't know about the Guns Out TV event at XCal in Ashburn, Virginia, I'm not too far from that way. And Crumpy, I'll see you there. And anyone else that's joining us, we'll see you as well.
Yeah, there are a few people that are coming.
That's a big squirrel you got there, Dark. Hey, no.
All right,
Who's
guys. That's it. I'll see you guys later and have a great day. Bye.
Say bye-bye. Wow, hamster.
How's this taking forever to end?